Mr. Pensa, friends, ladies and gentlemen, distinguished guests, students, it's wonderful to be here tonight. Is the mic all right? I thank you, Mr. President, for including my family ties with Western University, the University of Western Ontario, but you left one out. They're even deeper than you suggested. There's Frank, my husband, and our sons Jim and Wayne. But my first husband, Rory McLachlin, who passed away much too young, was also a graduate of this university, and his family was deeply rooted in the traditions of this university. So I go back a long way. In fact, at one such event here, I said, every time I get a chance, I marry a man from Western. It is indeed a great honor to deliver the 2016 Pensa lecture. The honor is heightened by the distinction of Claude Pensa and his wife, late wife, whom I never had the pleasure of meeting, for whom this lecture series is named. In the course of a legal career spanning 6 decades, Mr. Pensa has worked ceaselessly to promote human rights and the peaceful resolution of disputes. My topic tonight, Canadian constitutionalism and the ethic of inclusion and accommodation, could not be more fitting. Modern governance is increasingly beset by a single overarching question. How can people of diverse culture and creed live peacefully and productively together in the bosom of a single nation state? Comment maintenir l'harmonie au sein d'une société marquée par la diversité culturelle? Voilà le défi auquel nous devons faire face. A century ago, the world took for granted that states were comprised of people who were more or less the same, looked the same, talked the same, thought the same, people who shared the same race, culture, religion, values. There was a certain range in which diversity was protected, but it was very narrow. And the assumption on which the nation-state, the dominant model of the 18th and 19th centuries, was based was that the people in the state would be essentially the same. That is no longer the case. Global travel and communications, combined with historic phenomena of exodus and exile, have exponentially increased the diversity quotient within most nation states. The world is quite literally on the move, pushing through the porous borders of Western democracies. Within those democracies, diverse groups vie for position, each with its own distinct voice. How is the nation state to deal with this? More and more, this is the critical question of modern governance. Current responses disclose 2 basic answers to this question, each with its variants. The first response is to minimize and deny and exclude. Keep the different people, the people who aren't like you, out if you can. Variants on this response include calls for restrictions on immigration and refugees, calls for deportation of foreigners, suppression of modes of dress and conduct that don't seem quite right to us, and more recently in the American arena, calls to build walls. The second response to diversity is to find ways for people of different backgrounds and cultures to live together peacefully, despite their differences, in a way that allows them to find common values, become productive co-citizens, and ultimately maintain trust in the social order. This approach allows differences to exist and seeks to accommodate them insofar as they do not run counter or undermine the basic legal and cultural values espoused in a nation's constitution and fundamental values. While the first of these 2 responses, the response of exclusion and negation, is largely in the hands of the politicians. And as you know, I'm a judge, not a politician, and so I'm not going to say very much about it. I only want to say that whatever its attractions, it has legal and practical limits. On the legal side, the matrix of international conventions and covenants to which nations have signed make it difficult for any civilized nation to exclude and eject people simply because they're different. On the practical side, economically advanced nations face twin truths. First, it's really difficult to keep determined people out. And second, we actually need people to come to our country and other countries to ensure that our economies continue to grow in a sustainable manner. After all, who's going to pay our graying demographics pensions? Because of these limits, these practical and legal limits on the response of exclusion and negation, it is unlikely, in my belief, to be complete or successful. Which brings me to the second response, which is my focus tonight, the response of inclusion and accommodation. This is the response that Canada, although not without some exceptions, has chosen. First, I want to ask why we as Canadians have chosen this response and look a little bit into Canadian history to find the answers. Second, I'll discuss how our Constitution and our laws have developed to support this response. And finally, I will discuss the boundaries of accommodation, the limits that the law and our legal system must inevitably impose on inclusion and accommodation. So let me begin with the Canadian response and why we are what we are in Canada. From the beginning, Canada has been a country of diversity. Diversity is both the country's fate and its salvation. Canada has never been a monolith. It's never had a single defining culture or language. We sometimes lament our lack of a defining culture or language. We see it as a deficit. But I don't think we should. Our deficit is also our benefit. This idea was recently echoed by our Prime Minister, who on a visit to England declared, and I quote, "Our diversity isn't a challenge to be overcome or a difficulty to be tolerated. Rather, it's a tremendous source of strength," end quote. Canada is known and respected throughout the world for its inclusive approach to diversity. Thus, in 2014, during a historic address to both houses of Parliament, His Highness the Aga Khan, the spiritual leader of Shia Ismaili Muslims, praised Canada for its leadership in the community of nations and especially its ability to articulate and exemplify a commitment to pluralism and what the Aga Khan called the cosmopolitan ethic. He said elsewhere that societies, and I quote, "can learn a lesson from the Canadian experience, the importance of resisting both assimilation and homogenization, the subordination and dilution of minority cultures on the one hand, or an attempt to create some new transcendent blend of identities on the other." Well, we'll carry on for the time being. Canada's inclusive approach to diversity is rooted in its history. We came together as a country out of practical necessity, and we have remained together for largely the same reason. As a consequence, we have developed our own unique ethic, an ethic of inclusion and accommodation. If you organize that, Mr. Dean, in order to get another room, congratulations. Canada's first people were, as the name proclaims, its Indigenous people. They in themselves were enormously diverse. We had over 75 tribes in this country scattered across a vast landscape, 50 to 70 different languages, widely varying cultures from the farming cultures of the Iroquois and Hurons, the trapping and sealing cultures of the north, the hunting cultures of the Great Plains, and the fishing cultures of the West Coast. And then came the Europeans. Compelled by the harsh climate and difficult terrain, Canada's first European colonists had little choice but to rely on and learn from the Indigenous people, and to work with them as equals. Over 400 years ago, Samuel de Champlain sailed from France and alighted on the eastern shores of what is now Canada. He spent 3 decades on and off exploring the eastern and central parts of Canada. He lived with the Indians, writing and filling his sketchbooks with what were to him their strange and diverse, but very useful in many cases, practices. With the arrival of the Europeans, a critical question arose. Would the newcomers be like the Spanish in Central and South America, conquering and suppressing and enslaving the indigenous population? Or would they adopt a more inclusive approach? In Canada, for the reasons I've mentioned, and probably others, the answer was the latter. Confronted with the harsh climate, the uncharted wilds of the future Canada, our early colonizers had little choice but to enlist the assistance of the local populations. They had to get along. Champlain, the first of them, set the pattern. Champlain's writings and depictions of the people he found are imbued with admiration and respect. He was a Frenchman who knew nothing of the forests and rivers of Canada, much less its icy winters, and he would have perished without the skill and wisdom of the Indigenous people he found. In the wars of later centuries, both the French and the English forged shifting symbiotic alliances with Indigenous peoples. And by and large, during this period, Europeans and Indigenous people fought together. The same story unfolded in different ways as exploration moved westward onto the prairies and through the mountains to the Pacific coast. If 19th century Europeans were better able than Champlain had been to endure the rigors of the West, they still needed Indians and Métis to guide them as they explored the new terrain. And the Royal Proclamation of 1763 committed the Europeans to treat, and that's the word it used, with the Indigenous population, sparing Canada the Indian wars that raged south of the 49th parallel. And inherent in that word, the obligation to treat, quote unquote, is the idea that you have to treat people as equals. You have to get their permission to take their lands. You have to respect their dignity and their autonomy. The result was that relations between early explorers and Indigenous peoples developed in a way that on the whole was marked by a spirit of interreliance based on mutual respect. It's a story that John Ralston Saul describes in his book, A Fair Country. Sadly, as our country's subsequent history records, the relationship between Europeans and Canada's Indigenous people was damaged, and we are still in the process of mending it. But my point is that the early interactions set the pattern, which is still, I believe, the defining characteristic of Canada, a pattern of mutual respect and cooperation. Just as diversity characterized the early interactions between Europeans and Indigenous people, so diversity lies at the heart of the birth of modern Canada. The country, as you know, came together in 1867. It was a union, however, of two very different peoples, the French and the English, les Français, les Anglais. They spoke different languages. They practiced different religions. They suffered from the accumulated hostilities associated with a century of intermittent war between France and England. After the British conquest of 1763, the question arose for England, how are we going to treat all these French Canadians that we have inhabited? They were much more numerous than the English-speaking settlers, and England had just come off a bruising loss of the American colonies to the south. So in the end, the route of accommodation was taken. And in 1763, the Quebec Act was passed. It really was remarkable for the time when conquerors were entitled, it was thought, to make whoever they conquered speak the language that they had, adopt the laws that they wanted adopted. The Quebec Act gave Quebec the right to continue to use the French language, to continue to have the civil code as its law, and to continue to embrace the Catholic religion. It was a remarkable and unusual for the time act of accommodation. The same pattern of university through diversity led almost a century after the Quebec Act to the Union of the Provinces of Canada. The English-speaking provinces of the Maritimes and Upper Canada, what is now Ontario, and what is now Quebec. And the new Constitution, the BNA Act of 1867, enshrined the same sort of protections for minority language and religions as had been enshrined in the Quebec Act. Once more, accommodation, recognition of difference, but finding a way to live together in harmony. Mutual respect and cooperation continued to define Canada as successive waves of immigration washed over the country. The Great Migration of Canada brought over 800,000 people from Britain between 1815 and 1850. At the end of the 19th century and the beginning of the 20th, immigrants from the UK, Europe, the US, and China flooded into Western Canada. In 1913, the high point of Canada's immigration saw over 400,000 immigrants come to the country. Influx continued through the Roaring Twenties, and the aftermath of World War II brought large numbers of refugees and immigrants from various European countries. 1.5 million came from Europe in the 1950s alone. Refugees followed in the thousands in the years that followed from places as diverse as Uganda, Chile, Vietnam, Kosovo. Between 2009 and 13, Canada admitted an average of 250,000 new permanent residents every year, and last year it was estimated, and we still haven't finished counting, I guess, but the best figures put it between 260 and 285,000. And we're all familiar with the story of the Syrian refugees who came recently to our country and are currently being located by the government and citizens who are working together to establish this latest group to come to our shores. To sum up, Canada has from the beginning been a place of diversity. We could never, and we were never, be. We could never be, and we were never a monolithic nation state. We have always had to recognize diversity, accept diversity, and work with diversity. Our history is not a history of exclusion, subjugation, or exile. It's not a history of building walls. It's a history of coming together in full recognition of our differences and working out those differences in the spirit of mutual respect. In a multicultural global world where other nations are struggling to deal with diversity, we, despite imperfections, have set a high mark. This brings me to the second part of my talk, the Canadian Constitution and how it has responded and how it reflects this ethic of inclusion and accommodation. Nations shape their constitutions, and constitutions shape their nations. So we should not be surprised that the ideas of inclusion and accommodation, so central to Canada's history, are reflected in Canada's Constitution. But before I pursue this idea, allow me to briefly digress to say what's involved in Canada's Constitution. We think of constitutions first and foremost as covenants, words written on pieces of parchment, and Canada's no exception. We have our covenants, we have our words, we have our pieces of parchment. We have our two fundamental documents, the British North America Act of 1867, which I've already mentioned, and the Constitution Act of 1982, which are the documents embodying our Constitution. Under the umbrella of the BNA Act, the 1867 Act, Canada grew from a fledgling colony to a dominion to an independent country that stretched from the Atlantic in the east to the Pacific in the west and the Arctic in the north. Its people fought with great distinction and equally great sacrifice in 2 world wars. Canada developed a robust economy and became a player on the world stage. But it wasn't yet fully independent. Its constitution could be changed only by the British Parliament. In that sense, it was still a colony. Nor did it possess a constitutional Bill of Rights. In 1982, after years of debate, planning, and negotiation by Canadians of all stripes, the British Parliament, at Canada's request, adopted the Constitution Act 1982, giving Canada the right in the future to amend its own constitution and adopting in constitutional form the Canadian Charter of Rights and Freedoms. Together, the BNA Act and the Constitution Act of 1982 form the Constitution of Canada. It is the words of those two documents that the courts interpret when constitutional questions arise. However, this is not an entirely complete picture. Not everything we think of as constitutional is spelled out in the words of those two documents. For example, the BNA Act does not refer to the Prime Minister or the Cabinet, nor does it mention that a government's mandate rests on maintaining the confidence in the House of Commons. Yet such principles are undoubtedly part of the Canadian Constitution in a large sense. We call them constitutional conventions. And over and above constitutional conventions, the Supreme Court of Canada, in the secession reference in 1998, that was the reference about whether a province, notably the province of Quebec, could secede, identified certain fundamental principles that imbue and underline the Canadian Union and its Constitution. One, the principle of federalism. Second, the principle of democracy. Third, the principle of constitutionalism and rule of law, and finally the principle of, get this, respect for minorities. And these have been called the basic structure, or implicit in the basic structure or architecture of our constitutional arrangements. The texts of our fundamental documents, the BNA Act and the 1982 Constitution Act, read in light of constitutional conventions and the fundamental norms underlying the Constitution, together described by what we mean by Canada's constitutional arrangements. Against this background, I return to the question with which I began. How does our Constitution reflect the ethic of inclusion and accommodation? As I've already mentioned, the very existence of the BNA Act testifies to inclusion and accommodation. It represented a compromise. The federal government was given certain powers, and the provinces, the former colonies, were given others. But beyond that, it affirmed the French-English duality of the new country and granted religious and language rights to minorities within Quebec and the other provinces. In these ways, it reflected the fact that Canada was based on the coming together of diverse peoples, and that cultural traditions, linguistic traditions, legal traditions were entitled to respect and must be accommodated. The Constitution Act of 1982 also carries the ethic of inclusion and accommodation and takes it further. First, by giving constitutional recognition and affirmation to Aboriginal and treaty rights of Canada's First Peoples, and second, by introducing a constitutional Bill of Rights, the Charter of Rights and Freedoms. And the students in the room will certainly be very familiar with this document. The Charter, as you will have learned, is a document of inclusion and accommodation suited to the diverse makeup of Canadian society. The rights and freedoms the Charter refers to are guaranteed equally to men and women. Section 27 instructs us to interpret the Charter, and I quote, in a manner consistent with the preservation and enhancement of the multicultural heritage of Canada. And the rights guaranteed by the Charter are all underpinned by the principle of the innate human dignity of each person, the fundamental principle that underlies all human rights. This truth was recognized early on in the life of the Charter by the first woman on the Supreme Court of Canada, Justice Bertha Wilson. She said, and I quote, "The idea of human dignity finds expression in almost every right and freedom guaranteed by the Charter. Individuals are afforded the right to choose their own religion and their own philosophy of life, the right to choose with whom they will associate and how they will express themselves, the right to choose where they will live and what occupations they will pursue." I pause to interject a note. Bertha Wilson was still on the court when I became the third female justice on that court, and I had just taken my oath, and I resumed my seat, and she leaned over and whispered to me, there are 9 people on our court, of course, 3 down, 6 to go. Well, getting back to the dull stuff, perhaps nowhere in the Charter is the principle of human dignity better expressed than its central guarantee of inclusion, the guarantee of equality, Section 15, which says that every individual is equal before and under the law, and it goes on to say, without discrimination based on race, national, ethnic origin, color, religion, sex, age, or mental or physical disability. In other words, everyone has a place in Canada. Finally, the Charter's very first section embodies the practice of compromise, balance, and accommodation, so essential to making diversity work. The Charter is this lovely document. It sets out all these wonderful rights and freedoms. Freedom of speech, freedom of religion, democratic freedoms. And then it says it right up front, Section 1. We're giving you all these freedoms. Enjoy them. However, the state has the right to limit them. So, they are not absolute. This is accommodation. This is how the accommodation works out under the Charter. Section 1 provides a way to balance the public interest in achieving an important goal with private rights that may be infringed by a public measure. For example, free speech or freedom of religion may be required sometimes to yield to laws that are aimed at preventing harm to others. Sometimes speech can harm. Sometimes religious practices can harm. In the good of society as a whole, such practices can be curtailed, and that is done under Section 1. Insofar as reasonably possible, individual rights should be respected and accommodated, but sometimes where they unduly impinge on other, even more important interests and values, they may be limited. Section 1 is the mechanism for resolving the tensions inherent in the diverse society in which we live. This brings me to the final part of my talk, how in practice our Constitution works to impose limits on rights and the implications of this for the ethic of inclusion and accommodation in a diverse society. When diverse peoples live together, conflicts are bound to arise. Lines must be drawn, people insist. This or that type of conduct should not be tolerated. On the other side of the equation, the person affected may assert that it's his or her right to behave the way they do, and that right is guaranteed by the Constitution. And so we have essential conflict from time to time. It is really important that a diverse country that is committed to peace and democratic governance have ways to resolve these conflicts when they arise. And we do that in our country through many institutions, but not unimportantly, perhaps primarily, through the courts, through the rule of law, through various tribunals and other peacemaking institutions which lie at the heart of our society. We're all familiar with stories from other parts of the world that sadly remind us that from time to time, the inability to resolve intercultural or religious conflicts in a peaceful manner, in a timely manner, can lead to violence, war, even genocide. It's not enough for a nation to possess an abstract ethic of inclusion and accommodation. It is also necessary to have in place a method of avoiding clashes if possible and resolving clashes when they cannot be avoided. The law does both things. Through statutes or through cases, it tells us where the lines are likely to be drawn so that we can avoid clashes. and when they occur, it provides a way to resolve them. The Canadian Constitution confers this essential task actually on all three branches of governance. The legislative branch, which is Parliament and the legislatures, the executive branch, which is the cabinet and the various agencies that carry out the law, and the judicial branch, the courts. The primary responsibility, I think, for balancing the interest in individual rights with public interest, finding the compromises between conflicting rights and interests, lies with Parliament and the legislatures. Section 1 of the Charter, as I mentioned, allows legislatures to pass laws that limit rights and freedoms, provided that those laws have an important goal and are measured and proportionate. The first step in the process of accommodation is laws on the books that achieve this balance and signal to the public where the lines are to be drawn. A host of laws, ranging from the mundane to the exceptional, draw such balances. By and large, the lines set out by the laws passed by Parliament and the legislatures are respected. Such laws are preventative. They set out the norms of accommodation and thus avoid conflicts that might otherwise arise. The executive branch of government, which is responsible for applying the laws that the legislative branch passes, must also function in a way that appropriately balances the public interest with individual rights and finds just solutions for conflicts between rights. Thus, the Supreme Court has held that the decisions of ministers and administrative agencies must respect charter rights and find the appropriate resolution under Section 1 of the Charter. The final but essential responsibility for balancing rights against conflicting public interests and resolving conflicts between people about these rights and interests lies, of course, with the courts. Sometimes this involves a constitutional challenge to a law. A person comes to court and argues that the balance that a particular law strikes is unconstitutional, and therefore, under the terms of the Charter, is invalid. And the courts are called on in such cases to decide whether the law actually violates the Constitution. Some people call, and when the courts so decide, some people say the court has struck down that law. In fact, I prefer to say the court has done its constitutional job of declaring an inconsistency between the law and the Constitution, at which point Section 52 says that to the extent of the inconsistency, the law is not valid. But in other cases, the challenge is not to the law itself, but how it is applied. It's applied, the allegation is, in a way that has denied a particular charter interest or sets the balance in the wrong place. Let me give you an example of each of these two kind of cases. The recent decision of the Supreme Court on the right to assisted dying, the Carter case, offers an example of a challenge to a law on the ground that it infringes a charter right. For a very long time, suicide and attempted suicide were both crimes in Canada. In 1972, as a sign of changing values, the criminal code was amended, and suicide was no longer a crime, but assisted suicide remained as a crime. Since the 1990s, there have been calls for the decriminalization of assisted suicide, at least to the extent that people who are in the final throes of a debilitating disease or otherwise needing help in dying could obtain that help without criminalizing the doctors and others who might assist them. The claimant in Carter, the case we heard just last year, suffered from ALS, an incurable disease which causes progressive muscle weakness and results ultimately in death. Anticipating her bleak future and aware she could not help in ending her life when it became unbearable without putting other people's lives in jeopardy, or at least jeopardy of criminal prosecution, this woman brought a claim in the British Columbia Supreme Court challenging the prohibition on assisted suicide. The case pitted the need to protect the public from the risks inherent in assisted suicide against individuals' fundamental right to life, liberty, and the security of person. Our court ruled that the balance struck by Parliament in the criminal code was too draconian and hence unreasonable. Although Parliament's goal was to protect vulnerable persons from being induced to commit suicide in a moment of weakness, which is an admirable goal, an absolute prohibition was more than what was necessary to achieve this goal. Not everyone who wishes to end their life is vulnerable, and an absolute prohibition is unnecessary if you have a permissive regime with properly designed safeguards. These matters had been established in the evidence below, and we took them as such. In essence, faced with a clash between a fundamental right and a law, the court was required to solve the conflict, and we declared, as you know, that to the extent that in some of these extreme cases it prevented getting help, the assisted suicide law was too broad. It was sent back to Parliament, and Parliament is now wrestling with what law should replace it. The second kind of situation where these conflicts arise before the court is where the law isn't challenged, as I said, but where it's alleged that the minister or tribunal or some other person involved with applying the law applied it in an unconstitutional manner. And I'll mention here another case which you may recall, which was the case of R versus NS, which is sometimes referred to as the niqab case. And this is an interesting case where two men were charged with having sexually assaulted a woman. At the trial, the woman wished to testify, but she was a Muslim, and on the basis of her, it was actually on the preliminary inquiry, on the basis of her religious belief, she sought to wear a niqab, which is a face covering, except for the eyes, in court. The accused persons objected. They relied on the age-old right of an accused person to confront his accuser and to have effective cross-examination, which it was argued depends on being able to see the facial expressions as certain questions are put. So this was the essential conflict. Religion and a sincerely held religious belief on the one hand, and on the other, this fundamental, or so it was argued, right to confront one's accuser and to have full and effective cross-examination, which is essential to a fair trial. There were a number of possible ways this could have been resolved, and they were pressed upon us. One way was the response of exclusion. This argument goes something like this. The right to a fair trial means that religion has no place in the courtroom. A witness must therefore always remove her face covering on the witness stand because it might get in the way of proper assessment of credibility. Another response was at the opposite extreme. It was argued that the right to freedom of religion is paramount, with the result that the witness should be able to wear her niqab on the stand in all circumstances, provided that her sincerely held religious belief required that. The majority of the court, in the end, chose a middle way, a way which might be described as accommodation. We rejected both extremes. We noted that traditionally in Canada, potential conflicts between freedom of religion and other values have been solved by respecting and accommodating the religious belief to the extent that in the facts of a particular case, this can be done. To accommodate religious beliefs, employers have been required to adapt their workplaces, and schools, cities, and legislatures and other institutions have done the same. Courts, the majority said, are no different. Consequently, a witness should be allowed to testify with their face covered, provided that this does not impinge the accused's fair trial rights, and it will be for the judge in the particular case to determine when and if that arises and make an order accordingly. No bright line, but a very contextual, case-oriented approach that preserves the freedom of religion insofar as it can be preserved compatibly with fair trial rights. Let me conclude this review of accommodation and diversity in the courts by turning to the need to resolve the rights of Canada's Indigenous people with conflicting, or so it may appear, rights of non-Indigenous people. As I've noted, Section 35 of the Charter guarantees the rights of Canada's Aboriginal peoples, rights found in treaties or deriving from Aboriginal custom and use of land and sea and resources. In practice, these rights may come into conflict with other rights, like property rights or development rights. Moreover, in some cases, the Aboriginal right is inchoate, at least in legal terms, and must be given a legal definition before matters can be resolved, a definition which in itself may have to consider conflicting interests. The task of resolving these delicate and important issues has fallen in large part to the courts. The courts have held that the dominant dynamic in the resolution of these issues is the idea of reconciliation, a robust and fair recognition of First Nations' place in our society, coupled with an appreciation that the way forward is through respectful accommodation of diverse interests. Let me conclude. I began this lecture by asking how the nation-state can address the diversity inherent in contemporary democratic societies. This is critical. If we are to live together in peace, if we are to prosper into the future, people from different cultures must find ways to accommodate their differences under the Constitution. The approach I have described, what I call the Canadian approach, is one that for the most part is marked by inclusion and accommodation. Canadian philosopher James Tully, in his book titled Strange Multiplicity, Constitutionalism in the Age of Diversity, likens our Constitution to the spirit of the Haida Gwaii, which is a sculptural masterpiece of Haida artist Bill Reid. You may have seen it in the Vancouver Airport Terminal, or if you didn't get that far west, on the backs of some older $20 bills. A large, dark bronze, traditional Haida canoe, carrying a motley crew, the raven, the grizzly bear, his wife and cubs, the eagle, the frog, and as the focal point in the center, the human shaman. Tully tells the story of his constitutional metaphor as follows, and I quote, "The passengers are squabbling and vying for recognition and position in their little canoe, each in their culturally distinct way. They are exchanging their diverse stories and claims because they're talking. As the chief appears to listen attentively to each, hoping to guide them to reach an agreement." End of quote. Over the centuries, the passengers in the Canadian ship of state, the Indigenous peoples, the European settlers, the immigrants and refugees, have all contributed to the conversation that's going on in our little boat in their unique ways. They have squabbled, they have vied for recognition. But what distinguishes the Canadian experience from so many others is that that's not all that they have done. They have listened to each other. Sometimes belatedly, sometimes incompletely. But more than in many nations, they have shared their stories in a spirit of respect, and from that respect has come accommodation and agreement. The result of this process is an overarching story that belongs to all of us. A story of rights and their limits. Rights and limits enshrined in our Constitution and preserved by our legislatures, executives, and courts. By striking the balance between the rights and their limits, the Constitution has shaped the values to which we are committed, and in the process forged our identity. Sometimes the process is difficult. Often it is imperfect. But it is the only process we have. As Tully reminds us, diverse as we are all in the same boat. Nous sommes toutes et tous dans le même bateau. Or as my predecessor, Chief Justice Lemaire, put it in Delgamuukw versus British Columbia, a case dealing with reconciliation of Aboriginal rights with other interests. And I quote, "Let us face it, we are all here to stay." I leave you with the words of Bill Reid himself, the Indigenous artist behind the spirit of the Haida Gwaii, and a man who understood profoundly the value of inclusion and diversity. Bill Reid said this, "Here we are at last, a long way from Haida Gwaii, not too sure where we are or where we're going, still squabbling and vying for position in the boat, but somehow managing to appear to be heading in the same direction. At least the paddles are together, and the man in the middle seems to have some vision of what's to come." Thank you very much. Merci.